Here we go. So first of all, good afternoon and a very big welcome to the first Your Employment webinar of 2022, providing you with essential employment law and HR updates. For those of you who are new to our webinars, we are of course Jones Chase Employment Lawyers. We act for a number of companies from PLCs all the way through to startups and some fantastic individuals as well. And we have a very high success rate of looking after those that we represent. I would just like to quickly introduce you to the speakers today. So my name is Dean, I'm the firm's managing partner. I'm covering the new return to work movement that's happening. We've got Harriet, one of the firm's senior associates.
Hi, everyone. And
we've also got Susanna, one of the firm's partners.
Hi, everyone.
Okay, and just in terms of format for the webinar, if you have any questions, please use the Q&A box. If you want to do that anonymously, please hit the anonymous button. If you don't mind your name being displayed, you can use the chat function as well, which we'll also be keeping an eye on. And importantly, just to keep the conversation flowing, if you want, it is useful for us if you select the all panelists and attendees menu option on the drop-down menu. So everyone in the webinar can see what your questions are. And again, if you want to keep your question anonymous, please hit the anonymous box. I should add as well that we are recording the webinar to distribute this to a wider audience. So if you are asking questions and you want to do so anonymously, please hit that anonymous button. Once again, the points that we're covering today do not constitute formal legal advice. So much depends on the facts of the case, and sometimes the approach that you take in one case is not the approach that you take in another. So please don't rely on this webinar for constituting legal advice, and definitely drop us a line if you have any questions. Another quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 27th of January 2022. Things are changing very quickly as ever, and do drop us a line if you have any further questions. And we do appreciate that everyone's time is precious, so we'll be finishing today at 5 o'clock, if not before. And lastly, at Jones Chase, we do like helping people very much. So if you have any further questions or issues that you want to run past us, please do get in touch. I'm sure you've all got our contact details, but they're all on the website, www.joneschase.com. We'd be delighted to have a chat with you. And lastly, we very much like, we do like referrals. So if you're happy with the advice that you're getting, and hopefully the vast majority of you are, yeah, please feel free to recommend us to others. We do like helping more and more people, and we're looking to grow the business as much as possible. So moving quickly on to the content, I'll just pass over to Harriet, and she's going to talk to you about the year ahead and what key employment law changes are coming up in 2022. So over to you, Harriet.
Thank you, Dean. So there's been an awful lot going on in employment law over the past 2 years. Most notably due to the COVID pandemic, which we've obviously been covering a lot in these webinars. And we wanted to have a look at the beginning of this year at what some of the employment law changes might be, so that you know these are coming up and help you prepare for them. You may be relieved to know that I'm only going to cover one, which is related to COVID. So we're looking at a few different topics. So first of all, I wanted to look at the Promised Employment Bill. This was actually announced in the 2019 Queen's speech, and obviously it's been delayed undoubtedly due to the challenges presented by the pandemic, but the government has confirmed that the bill will be published when parliamentary time allows, and it's hoped that this will be sometime this year. So I just wanted to have a look at some of the things that the bill is promised to include, which may have most relevance to you, and just to run through these. So the first one is a new right to 1 week's unpaid leave for unpaid carers. According to the government's consultation, which was published in September last year, this would be a day one right, and the leave could be taken in one block or individual days, and it would be for caring purposes such as personal and practical support, financial matters, personal or medical care. The next is another potential new right, which is statutory neonatal leave and pay for parents whose babies require neonatal care. And this would give parents the right to take an additional week of leave for every week their baby is in neonatal care, up to a maximum of 12 weeks. And it's expected to be available for those with 26 weeks service and who earn above the minimum pay threshold. Next up are some changes to flexible working. You may have been aware of the consultation document called Making Flexible Working the Default, which was published in September last year. And this document set out various proposed reforms to the existing right to request flexible working. The proposals don't extend to an automatic right for employees to work flexibly, but they do include a number of measures which would broaden the scope of the right, whilst retaining the basic system involving a conversation between employer and employee about how to balance work requirements and individual needs. The main change set out would be removing the requirement for 26 weeks qualifying service, which would make the right a day one right for employees. And the consultation also considers whether changes need to be made to the 8 business reasons for refusing a request, or to the sort of administrative process underpinning the right. And the consultation also sought views on whether whether an employer should be required to suggest alternatives to the arrangement put forward by the employee instead of rejecting a request outright. The government's decided not to proceed with a proposal to introduce a requirement for large employers to publish their flexible working policies. So the consultation closed on the 1st of December, and we're waiting for the response from the government. So we will update you once we get some more information on flexible working. The next interesting change is the proposal to extend redundancy protection for pregnant women and new parents. As you may be aware, under Regulation 10 of the maternity regulations, before making a woman who's on maternity leave redundant, an employer must offer her a suitable alternative vacancy where one is available with the employer or an associated employer. The proposed change would be to extend this protection to pregnant women from the point they notify their employer that they're pregnant until 6 months after a mother has returned to work. Currently, the protection is only when the individual is on maternity leave. So it starts when the maternity leave starts and it ends when maternity leave ends. So this would be quite an extension to that right. And it will also apply to those taking adoption and shared parental leave in some form. So that's obviously a really important potential change to look out for. Just a few other points on this. There's a potential for a creation of a new single enforcement body, which would look to enforce breaches in relation to national minimum wage, modern slavery, employment agencies, statutory sick pay and holiday pay for vulnerable workers. And it's got new powers, will have, if it's created, new powers to tackle non-compliance. And this includes civil penalties of up to £20,000 per worker for the breaches under the Gangmasters licensing and employment agency standard regimes. So depending on what the breach is, obviously that's quite a significant penalty, so something to be aware of. Next, a proposal for a new right for workers, which includes those on 0 hours contracts and agency workers, to request what's been referred to as a more predictable contract after 26 weeks continuous service. And this is intended to provide more certainty about the number of hours or days they'll be required to work. And this recommendation has come out of the Taylor Review, which was all the way back in 2017, can you believe it? And the government did accept many of the recommendations coming out of that and has announced its intention to put this point into practice. So it's obviously been a long time coming, but hopefully that will be included in the employment bill. And lastly, it's been proposed there may be a new mandatory duty on employers to prevent workplace sexual harassment, which is obviously a really important change if this comes in. And it will include the reintroduction of protections for employees who are harassed by third parties, that's customers and clients, which used to be the case. We used to have that as the law, but then that got changed a few years ago, so it got taken away. So hopefully now it'll get put back in again. And it's also proposed that the 3-month time limit be extended to 6 months for bringing all claims under the Equality Act. And again, that's quite an important change. So consultations have concluded on all of these apart from flexible working. So it's just a question of waiting for when these things are happening. So look out for the employment bill and we will update you as and when we get any news on that. Now looking at mandatory vaccinations for COVID, there's been quite a lot of discussion about that very, very recently. So early in 2022, earlier this month, there were some changes made to the mandatory vaccination requirement, which was brought in to apply to care home workers in England last year. There were some minor changes earlier this month, but the wider change is due to take place on the 1st of April this year. And the change is to extend the mandatory vaccination requirement to those working in any other regulated activity, is the description, outside a care home. And regulated activities will include nursing and personal care, most forms of healthcare, including medical treatment, surgery, diagnostic services, ambulance services, midwifery and dentistry, among others. So it's pretty wide ranging. There are going to be limited exemptions for medical reasons. Those participating in clinical trials, those who are under 18, and some temporary exemptions for pregnant women and those who've recently tested positive for COVID-19. The NHS has published some healthcare workers guidance on this, and last week the government published some social care guidance setting out some more detail. So there is a bit more detail available, but it's still a controversial topic, and there was a debate at Westminster just this week, which is in response to a petition which has received over 220,000 signatures, apparently, calling for the government to prohibit employers from requiring staff to be vaccinated. And I think that many MPs believe that the requirement to vaccinate may severely affect the NHS, as it's thought that many staff may leave because they don't want to be forced to be vaccinated. And obviously that could have a big impact. The government says it's taking steps to mitigate this risk and seems intent on moving ahead with the plan. So it looks like it is going to come in, but obviously we can watch with interest and look out for developments. Moving on now to just some case law. Because there are a couple of interesting cases that are due to be heard this year around the area of the potential for conflict between transgender rights and religious or gender critical beliefs. And the two cases are Makareth and DWP, and Higgs and Farmers School. Just to let you know, we are going to be issuing a bulletin very shortly, which is going to cover all of these changes. So it will have these details in. So you can wait for your bulletin to come along, and things like the case names will be set out in that bulletin. And you may recall that the EAT decided last year in the case of Forstater and CGD Europe, which is quite well publicised, that a claimant's belief that biological sex is immutable was protected under the Equality Act. So this case is now returned to the Employment Tribunal, who will decide whether the non-renewal of her consultancy contract was unlawful discrimination because of her belief. But there are a couple of cases that the EAT is going to hear around this area, and Makareth is due to decide whether the tribunal in that case was wrong to hold that the claimant doctor's religious beliefs in unchangeable binary gender were not protected. I think the Forstater judgment gives us a good indication that the EAT is likely to uphold the appeal and find that his beliefs were protected. And if so, the tribunal will then look at deciding whether Dr. Makareth suffered discrimination because of his beliefs. And the discrimination was around the DWP ceasing to engage him when he refused to use patients' chosen pronouns. The other case regarding Mrs. Higgs concerns her being dismissed following posts on social media that the school considered to be homophobic and transphobic. Now, in this case, the tribunal did find that her religious beliefs were protected, which were that gender cannot be fluid, was what her belief is, but they found that her dismissal wasn't discriminatory on the basis that it was because of the inflammatory nature of her posts rather than the beliefs themselves, which is always a tricky issue. So the EAT is going to hear an appeal on this issue. So as always, we'll update you once we get the results. And I think this is a really interesting and fast developing area of law. The other case was just to mention a case on holiday pay. It's a case of Harper Trust and Brazel, which you may have heard about. There was quite a lot of publicity about it back in 2019. And it's now got to the Supreme Court, and it's about calculation of holiday pay, which is mainly relevant for part-year workers. So someone who works, for example, on a term time only contract. That's what the case mainly concerns. But it demonstrates also the complications of calculating holiday pay for workers with atypical patterns of work. So hopefully the Supreme Court's judgment is going to bring some much needed clarity to this rather complicated area of law. And just whilst we're talking about holidays, just a reminder that there will be an extra bank holiday this year to celebrate the Queen's Platinum Jubilee. And you may already be aware of this, but if not, the second May bank holiday is going to be moved to Thursday, the 2nd of June, with the extra bank holiday taking place on Friday, the 3rd of June. So obviously factor this into your delivery plans for your business. And we recommend that the wording in employment contracts is reviewed, because depending on the specific wording in the contract, it may not technically be necessary for employers to give their staff an extra day's paid holiday. If, for example, the contract states that staff get a certain number of days holiday inclusive of bank holidays, or wording similar to that, so not specific about the number of bank holidays. But bear that in mind and have a look at that. Next, I just wanted to say a word about menopause. As we've looked at this issue before, of how the menopause may impact workplace, and it seemed to gain a lot of traction last year, which is great, and seems to be a topic that people are really talking about. And as highlighted by a recent independent report commissioned by the government, almost 1 in 4 women end up leaving the workforce, and 25% consider giving up work as a result of the impact of the menopause. So this obviously amounts to hundreds of thousands of people who are impacted by it. And the successful claims were brought last year, where it was found the claimant had a disability under the Equality Act due to the symptoms of menopause. And there's been a very recent decision where a woman succeeded in showing that comments that were made about menopause were discrimination on the grounds of sex and age. So these cases are coming through a lot more, and we're seeing quite a lot more of it. And whilst we're awaiting the outcome of the Women and Equalities Committee's inquiry into menopause in the workplace, it's nonetheless, we would suggest, a good idea to get ahead of the curve, think about what steps you can take to address the impact of menopause for your staff if you haven't already. Such as training, a menopause policy, that kind of thing. And obviously this would be best practice, but you can see how many people that it might help, might otherwise be struggling. And obviously, from a risk management perspective, hopefully result in fewer discrimination claims being brought. And obviously, if you would like any support with this area, we'd be very happy to help. Just a couple more points to touch on quickly. I just wanted to mention the increases to statutory payment rates, which is obviously something that happens every year in April. And as mentioned, the bulletin that we're going to send out will set out what these changes are. So I'm not going to go through them now in terms of all the figures, but just broadly to mention the ones we've got are on 1st of April, we've got the national minimum wages and the national living wage increasing slightly. And then statutory sick pay increases on the 6th of April by about £3. And then on the 11th of April, we've got the sort of family-friendly payment, statutory maternity pay, etc., which is increasing by a few pounds as well. So you can look out for those different changes. Also, just to mention that national insurance contributions for employers and employees are set to rise on the 6th of April by 1.25%. And apparently this increase is aimed at funding health and social care, but will be replaced in April 2023 by a separate health and social care levy. And I understand at that time, the national insurance contributions will revert to their current levels. So just to be aware of that if you weren't already. And finally, my last change for 2022. Those of you who have EU operations, if any of you do, should be aware of 2 EU directives due for implementation by member states by the 1st of August. Now, obviously, the UK isn't obliged any longer to implement EU directives, but I'm just mentioning it because employers with operations in the EU do often wish to have globally consistent policies, so far as that's possible in each country. So you might want to consider these changes. And very broadly, the new legislation will include giving all workers a right to a written statement of their terms and conditions, minimum levels of paternity and parental leave, and a new right to 5 working days carers leave each year. So obviously that impacts you. It might be something that you might want to look at a little more. And that is the end of the changes I was going to mention. So look out for our bulletin, yeah, obviously we'll update you as the year goes on with any updates that we have to those changes.
That's great. Thanks so much, Harriet. And yeah, just a quick reminder for those of you on our email distribution list. our bulletin should be getting released either tomorrow or Monday. It's also going on LinkedIn as well, and feel free to follow us on LinkedIn at Jones Chase Employment Lawyers. Okay, that's great. Thanks, Harriet. And the next section of the webinar is Susanna, who's going to speak about whether there is a new implied term of procedural fairness. So over to you, Susanna.
Thank you. Hello, everyone, and Happy New Year, although we already are at the end of January, surprisingly. It's going so quickly. You may or may not have come across since the beginning of the year, this new talked about implied term of procedural fairness within disciplinary proceedings. I wanted to have a look at this and actually ask ourselves whether this is really going to have an impact or not for us in our day-to-day practical dealings with investigations and disciplinary procedures. So where does this all come from? Well, it stems from a Court of Appeal decision that was handed down in December 2021. And the case is Byrne versus Alder Hey Children's NHS Foundation Trust. Just sort of by way of some background about that case, and I will add both of the links for first the High Court case and the Court of Appeal into the chat, so that if any of you are interested in having a read of them, you'll have access to them. But this was a Court of Appeal decision which looked at whether the High Court had construed the terms of a document called the Maintaining High Professional Standards in the Modern NHS Framework, which actually was a procedure, process pretty much like a disciplinary procedure, setting out what you would need to do in terms of looking at misconduct issues within the NHS. And in particular, it was in respect of disclosure of documents that were in the possession of a case investigator to a doctor who was subject to an investigation. So what happened was Miss Burns was a doctor. She was under investigation in relation to her care of a young person who died. And she applied to the High Court for an injunction to stop the investigation concluding until she had been provided with disclosure of all documents, without which she said she would not have a fair opportunity to put her view of events. And she ran two specific arguments in support of her injunctive application. And those were that there was an express contractual requirement to provide her, so within the framework document, to provide her with full disclosure of all documents seen by the case investigator in connection with the investigation. And she also argued a second argument, which was that it was a breach of the implied term of trust and confidence not to disclose the documentation to her. Now, she was actually talking about a relatively minor amount of documents. There were some statements and also some correspondence that had taken place between the trust and the parents of the child that had passed away. She was unsuccessful in her injunctive application, and so she appealed to the Court of Appeal. She was actually only permitted to appeal the contractual argument about the express contractual right to have the disclosure. She wasn't permitted to go ahead with the implied term of trust and confidence argument. And again, at the Court of Appeal, they dismissed her appeal on the grounds. And I won't go into it because actually this isn't really the relevance about the implied term being introduced, but nevertheless, what they said in the Court of Appeal is interesting in that they said that the correspondence meant communications from one person to another, and by defining it relating to the case, it meant correspondence generated by the investigation process, rather than correspondence related to the subject matter of the investigation. So very firmly, actually, the Court of Appeal and supporting the High Court, saying that it was the case investigator's discretion to decide which correspondence and what documentation needed to be disclosed. But the hullabaloo about this implied term of procedural fairness being incorporated into disciplinary procedures within contracts of employment was something that came out of the Abita comments in the judgment from Lord Justice Underhill and Singh. And it's opened the door to the suggestion that we now have an implied term in a contract of employment imposing a duty to conduct disciplinary proceedings fairly. And that is an implied term that is separate to the implied term of trust and confidence. And in particular, within this case, Lord Justice Underhill commented that in respect of the obligation to give the doctor the opportunity to put their version of events, that implied that they must be shown any documents that they fairly needed in order to be able to do so. So why is this something that we should be thinking about and taking notice of? And in fact, do we need to really think very hard about it? Well, I think there's two things to look at here. First of all, up until now, when we've been looking at disciplinary procedures, when issues have arisen in relation to the process of investigations and the process of the disciplinary, we've definitely seen that employees are arguing that by an employer either not providing something to them or not dealing with, putting them on suspension for too long or keeping them, the process going for too long, that there's this implied term of trust and confidence that has been broken. And from an employee perspective, arguing that the implied term of trust and confidence is broken is a hard argument to run. To succeed, the employee must show that there is no reasonable or proper cause for the employer's conduct, and they've also got to show that the employer's conduct is calculated or likely to destroy or seriously damage the relationship of trust and confidence. And those hurdles are high for the employee to get over, and in some instances quite easy for the employer to succeed on. So by introducing an implied term into the contract of employment that disciplinary processes must be conducted fairly is actually providing a much lower hurdle argument for an employee, or in particular his or her lawyer, to advance to pursue a claim that an employer has breached the contract of employment. So if that's true, I mean, is this something that really is going to have a significant impact for you as employers? And how is it going to realistically impact us? Because we are already very familiar as employment lawyers and HR practitioners with the concept of procedural fairness. Certainly we are in respect of dealing with unfair dismissal claims, as this is directly linked to the tribunal's test for reasonableness. So when we're looking at assessing fairness from a tribunal perspective, we're looking at, did the employer follow a fair procedure? And we're looking at, did the employer act reasonably in treating the reason as a sufficient reason for its decision? And as you know, throughout an entire disciplinary process, that test of fairness applies throughout. So it applies during the investigation and it applies during the actual disciplinary hearing. And we're also very much guided by the ACAS Code of Practice on Disciplinary and Grievance Procedures, which again sets out in very clear terms what are the minimum requirements for the employer in relation to establishing a fair procedure. So in reality, I'm not sure that actually this is something that is going to cause us or employers a huge headache, because we are governed within our policies and procedures by this concept and clear notion that in order for us to follow through with any disciplinary process, that we do have to apply procedural fairness. And if we don't, and if the consequences that somebody is dismissed and we haven't acted procedurally fairly, then there is a chance, a good chance, that the claim for unfair dismissal will be upheld. But what I do think it might have an impact on, and it'd be interesting to hear what Dean and Harriet's thoughts are, is that I do think it opens up a new area that perhaps we haven't seen being pursued often by employees, which is this basis upon which an employee, and certainly you could see employees in senior positions who might want to cause aggravation, or who are very concerned about the stigma of dismissal on their to their careers, where we might see this being used more to pursue injunctive action against employers in order to halt disciplinary processes, arguing that a fair procedure has not been followed and that the company is in breach of the implied duty to follow a fair procedure within disciplinaries. It also certainly does impose on certainly for an employer, when looking at its processes, this requirement to look at each individual case and to see whether or not, dependent on the allegations and what the employee is asking for, as to whether or not they're being reasonable if they're refusing to provide documentation or refusing to follow certain processes. So it adds a bit of a hurdle, but in terms of real terms for me, I don't think that it changes our day-to-day dealings with how we're running our processes, and it certainly doesn't necessarily impose a new level of care that we're going to have to do, because we're already looking at that constantly when we're dealing with disciplinary procedures. Not sure if you, Harriet or Dean, have a view on it, having looked at this issue.
Yeah, well, Harriet,
you go, Dean.
No, I was just going to say I just totally agree. And whenever we're acting for claimants, as we do a lot of the time, we're always looking for reasons to knock the employer off balance in terms of its, or whatever it's trying to do. Most companies want to do things as quickly and efficiently and pain-free as possible to get through the process. So any reasons to try to knock it off balance, you'd use it. And acting for employers, obviously, we're very much making sure that the right fair processes are followed. And another point is acting for employees as well, is where there's a contractual policy. Multiple times I've used arguments that the employee is in breach of contract for any slight deviation from it. We've got a 5-minute video coming up about this next month as well. So yeah, I just totally agree, Susanna. Yeah, it could be used by claimants in the right circumstances, another weapon in their arsenal.
But it certainly doesn't give an employee the grounds on which to claim dismissal. They would still have to go down the implied route of trust and confidence, I think, to be able to claim constructive dismissal anyway. And then if you're looking at a breach of contract, I mean, really, you're going to be limited in terms of perhaps compensation that you could get in such a claim. But yeah, it's something for us to use potentially, but not.
I was just going to say, I think, you know, I totally agree with what you've both said. I think obviously injunctions are incredibly expensive. So for an employee to actually go ahead with the cost risk in the civil courts, I think is a very probably wealthy and brave employee. So I think it's something that might be threatened, but in terms of, you know, I think it would be a rare case for somebody to actually go ahead and seek to bring an injunction on that basis, is my view.
Mm-hmm.
I agree. Although I have, not recently, but towards the end of last year, certainly on something else, definitely threatened to injunctive proceedings to stop a process when we considered that it was unfair. So and I
threat, definitely
gone ahead and done it because their entire life was on the line and they weren't prepared to you know, to not try and protect their position. Company backed down, luckily.
Okay, we've got a question in from Rosie. And so could this be used by a union-funded case? Just wondering. Susanna, have you got an answer for that?
I think yes. I mean, could the union raise this as something as part of when they're supporting an employee through a disciplinary procedure? I think it's the type of thing that you can imagine a union rep would raise. But again, I'm going to put into the chat the two cases, and actually, if you've got time, the actual original decision is a 28-page judgment, so it takes a bit of time to read it. But what comes out of that very clearly is that the NHS had followed a fair process and had acted really very logically in relation to what they disclosed and what they didn't. And I think it's a really helpful reminder to show that common sense in these things and being transparent with what you're doing and how you're running a process gets you very far, certainly if it gets to a dispute in a court.
Okay, great. I'm just conscious of time in these webinars. I actually thought we were going to finish early today. It just never seems to happen. Anything else finally to add to your section, Susanna, or are you done? Okay.
That's it. Thanks.
Great. Thank you very much. Just two quick things. Number one, the lights in this office are going to go off in a second, so I'm going to stand up and switch them back on. Otherwise, I'll be shrouded in darkness for my section. I've worked that they run on a 20-minute time limit. Whilst I'm doing that, Harry, do you have something to add to your section? So I'll just hand over to you briefly. I'll be back in a second.
Thanks, Dean. Whilst I was speaking, it was pointed out that I mentioned the point about national insurance contributions are set to rise. Apparently, it's currently being discussed in Parliament as to whether or not that's actually going to happen due to cost of living increases. So I think on that one, perhaps don't take it that it's going to happen. Watch the news and see if that does actually see if that goes ahead. I just wanted to flag that.
Okay, fantastic. And Susanna, just because if people are watching the recording of this webinar, they won't be able to see the. If you would join just reading out the name of the case, the cases that you've just posted.
Sure. So the case is called. The actual case is Byrne versus Alder Hay, ALDER, new word Hay, HEY, Children's NHS Foundation Trust. High Court decision October 2021. Court of Appeal decision is December 2021.
Okay, that's brilliant. Thank you. Okay, and Harry, you finished your section there in terms of the update, right?
Yes. Thanks, Steve.
It's
yeah.
Lovely. Okay, just in the last 20 minutes of the webinar, I'm now going to cover my section, which is what steps do you need to take to safely and lawfully return your staff to the workplace now that the Plan B guidance to work from home if you can is being lifted. So we are finally here, and what does this mean for your company? And importantly, what should you be doing now? So feel free to write in the Q&A box or in the chat box what you're all currently doing. We'd be just quite interested to find out. Are you bringing everyone back to the workplace? Are you doing hybrid working or something completely different? So feel free to just put in there, and again, address it to all attendees and panelists should you wish to. So this is quite an in-depth area, and it's impossible to cover it all doing a short section on a webinar. So what I was going to say is that do drop us a line if you want to know a little bit more about anything that we're speaking about, or you've got a particular issue that you'd like to discuss with us. We do telephone consultations for within 30 minutes to an hour. We cover an awful lot of ground, and we can really help you to get on the right track legally. And usually the cost of the advice is massively outweighed by the benefits to the organisation. So yeah, would love to help you with any of this if needed. And I'm sure you've got our contact details, all of which are on the website, www.joneschase.com. So the first thing that I would like to do is to just take you through the government's working safely during the coronavirus guidance, which was updated today, the 27th of January, 2022. And curiously, the guidance says that it's going to be updated shortly to include more information on the current changes. It's not clear to me whether that means that what I've been looking at is the current up-to-date version or whether there's more updates, but either way, it's definitely best to just keep your eye on, it for further updates. And helpfully, it does say when it's been updated as well. There's a list, and the most recent update is again today, 27th of January. So what are the key points from the guidance? I think the first thing is that workers are no longer being asked to work from home if they can, which is a pretty huge change. Also, it says employers should talk to their workers to agree, a very interesting choice of words, I'll come on to that, to agree arrangements with their staff to return to the workplace. And also from today, the 27th of January, 2022, there is no longer a legal requirement to wear a face covering. but people are still advised to wear one in crowded or indoor spaces where they may come into contact with people that they don't normally meet. And where we're at in the country at the moment is that the COVID infection rates are still very high. And whilst the government is able to remove these blanket restrictions, there's still, I think, well over 10,000 people in hospital in England at the moment with the infection. And this has resulted in the government urging employers to act cautiously and to consider the risk of COVID-19 when moving back to Plan A, which is where we are now. Okay, so the current guidance says that there are 6 priority actions that you can take to protect staff during COVID-19, of which 5 are particularly relevant to employers. I'll run through these now. So number 1, the main part of the current guidance and our advice from Jones Chase is to carry out a health and safety risk assessment. And this really is the cornerstone of getting people back to the workplace. And with the risk assessment, the legal position is that all employers are required to carry out one, and the risk assessment should include the risk of COVID-19. Furthermore, employers have an obligation to take reasonably practicable steps to manage risks in the workplace. So that involves making changes. Something else we'd recommend, and is in the guidance, is that employers should also consider reasonable adjustments for workers with disabilities. And lastly, the guidance encourages employers to share the risk assessment results with the workforce. Okay, so that's really is the key point. Number 1 is to carry out a risk assessment with a particular emphasis on COVID, and to share the results of that with the workforce. And the second key thing is more of a practical point, is to provide adequate ventilation within the workplace, and there's a section on the guidance in that. The third section is to clean the workplace more often, and again, I won't go into that now, just practical things like using sanitizers, etc. And again, there's a section in the guidance about that. This the fourth point I'll spend a little bit more time with, and this says that employers should turn away people with COVID-19 symptoms. This includes customers and staff. And on this point, there is still a current requirement to self-isolate if you have COVID, and to book in a test as soon as possible, even if you're fully vaccinated. And just on this, so people must still currently complete their full self-isolation period. And although this has been shortened recently to 6 days if you have 2 negative lateral flow tests on days 5 and day 6. And also staff members must self-isolate if they're a contact of a person who has had a positive test result for COVID-19, unless they're exempt. And there's a number of exemptions within the guidance as well. And importantly, you must not allow a worker to come to work if you know that they have to self-isolate. It still remains an offence to do this. But importantly, the Prime Minister has stated that the self-isolation regulations expire on the 24th of March 2022, and he doesn't expect to renew them. So this could mean the end of mandatory isolation periods for people with COVID-19, although do keep an eye on this, it may change. And in any event, even if the regulations have expired, employers may want to take a different approach in practice anyway. It's worth emphasising that the current guidance doesn't supersede existing legal obligations related to health and safety, employment law and equality duties anyway. They sort of supplement all of those, but adopting a common sense approach here, doing the risk assessment, as I'll come on to, is a great legal and practical step to get people back to the workplace as well. The fifth and final key thing from the guidance I was going to speak to you about is that it says you must communicate what's happening with your staff and train them as well. And in this regard, there's a section for office workers within the guidance. And this says that you should talk to your workers to agree, again, interesting choice of words, arrangements to return to the office. You must consult with workers and trade unions where appropriate. You should remain responsive to workers' needs and consult with them on any health and safety measures that you've put in place to reduce the risk of COVID-19 spreading. And furthermore, you should give extra consideration to people at the higher risk of severe illness from COVID-19 and to workers facing mental and physical difficulties. Okay, so where does all of that leave us on the subject of getting staff back to the workplace? So what I would say on this is as follows. Firstly, check the contractual position. Most employers will have contracts that still say the normal place of work is the office. So I guess for current purposes, that could be good news if you want people to come back. Secondly, and as we've mentioned in previous webinars, employees dangerously can gain an implied right to work from home. if you don't take action in this regard. So you do need to get on top of the contractual situation. For example, every day that goes by where somebody's working from home, whether under a hybrid or working from home arrangement, there could be an implied acceptance, an implied contractual acceptance by the employee that working from home is fine, and it could become contractual. So that would then cause problems with any provision in the contract that says you need to be working from the office. And so again, unless you pay careful attention to your contractual arrangements, people could be gaining an implied customer practice or an implied contractual right to work from home. This could be quite dangerous. And so what we would say in that regard is, importantly, just do now particularly get on top of your contracts and the contractual provisions and your policies. We can definitely help with this if need be. We've got some fantastic precedents and some wording that you can use. And also as well, if you're not planning on getting everyone back to the office, if you're planning on implementing hybrid working and also, or just working from home permanently, definitely now get on top of the contractual provisions for doing so. That we don't have time to go into everything that a hybrid working policy needs, or a working from home policy doesn't. It's super important now to get key contractual protection in place for the business, particularly because I think we don't really know how these arrangements are going to work out. You do want an express contractual right to revoke these arrangements, to revoke home working or hybrid working if it really doesn't work for your business. And also another important thing you can build in contractually is a trial period as well. So rather than just commit to a permanent change to terms and conditions, you can have a trial period with the right to revert once again. And lastly, it goes without saying that your contract and policies all need to be harmonized and they need to work together. It doesn't make any sense to have a hybrid working policy or a home working policy if the contract says something different. So that could give rise to confusion and a bit of a mess down the line. Yeah, so once again, this is something we do as a firm. So if you need any guidance or a quick consult on that, definitely drop us a line. We'd be happy to help you. And I'm just going to double check if you've had any questions in, because we've had one prior to the webinar. Sorry, just bear with me, let's just have a quick look. No, I think we're pretty good there for the moment. And so we have had a question in prior to the webinar. This is from Laura, and she's asked for further guidance on how to encourage employees back to the workplace and what to do if they refuse to attend the workplace. So I'll just quickly run through what we think about this. So firstly, again, double check the contractual position. What does your contract say? Where's the place of work? Check your policies as well. If need them, get them updated. Again, we can help with that. And then I think the next step is to agree a uniform position from a management perspective, and then communicate this with your staff. So when you're communicating it with them, do so as early as possible. And that's going to be important to ensuring a smooth return. Invite feedback from the employees, make them feel involved, I think is important, and they will feel more reassured if at least the perception is that they are buying into the arrangements as well. And so just bear in mind that people are not in the office to talk about management messages. So just sending a long email may not be the best way to communicate with people, we think at the moment. You may want to think about moving to video or conference calls, Zoom calls as well, to get a bit of a dialogue going. If another point is that if some staff members have any particular concerns, you should deal with these on a case-by-case basis and consult with them so you can really understand what it is they're concerned about. Some people may have disabilities, other beliefs, or particular anxiety about returning to the office or workplace right now. Deal with every case in this regard on a case-by-case basis. We definitely advocate that. But ultimately, what you want to do is to give your staff a clear and direct management, a reasonable management instruction that is ideally backed up contractually. So you just want to make that really clear. And again, as I mentioned earlier, share the results of your risk assessment with them. So definitely do a risk assessment. Make sure you believe it's safe for everyone to return to the office and share that. A couple of other quick points is just be careful about whistleblowers or people who report that they don't feel it's safe enough currently to come back to the workplace. Don't ignore that, you need to act on it. And other people could, under section 44 and 100 of the Employment Rights Act, say there's a health and safety reason for not attending the workplace, that they don't feel safe enough to do so. Again, ignore that at your peril. That can give rise to some considerable legal problems. And so for those people, if you've done all of the steps, and then for those people who still don't return to the office, you can deal with this arguably, although again, just this is a very general approach I'm taking here. You need to look at it on a case-by-case basis. But ultimately, if everything is in place, then you could deal with it as unauthorized absence, which is a disciplinary matter. And provided you're acting reasonably as an employer, then ultimately disciplinary proceedings could be commenced for unauthorized absence. And furthermore, you may not need to pay for that absence as well. And so I appreciate I've covered an awful lot of points here quite quickly, but ultimately, if you've done all the steps that you need to, you are entitled to have confidence with what you were doing, and definitely press ahead with that. And we would say, as your employment lawyers, don't just succumb to employees' whims. You do have the ability to get people to return to the office. Okay, so that's the end of my section. I'm not sure if there's been any questions raised as it happens. Nope, so pretty good. Okay.
I might add, one of the things I think I've picked up is that if you're going to discipline somebody for failing to follow reasonable instruction in relation to returning back to the workplace, you do often that can be in somebody's gross misconduct in the disciplinary procedure. Failing to follow reasonable instruction can be sometimes included as either serious misconduct or gross misconduct. But I think the guidance I'm getting, or what I'm seeing through the case law, is that you would be a brave employer to go straight to dismissal for a first failing to follow reasonable instruction. I mean, what we're seeing is that exactly what Dean said, which is that you should really be sitting there and talking to your employee to understand and try and address their real concerns about coming back into the workplace. But then equally, the case law that we have had coming through is showing that employees who are just saying, I don't want to come back into the workplace because I don't feel safe because of COVID-19 or Omicron or whatever, those just having that fear of that actually isn't necessarily a reason that the courts will uphold as saying that justifies you not coming into work. So it has to be linked with a direct failure to provide a safe place of work is effectively where the case law is landing. So those would be my observations in terms of trying to manage people back into the workplace.
Yeah, that's right. Anything to add? We've had a question from Rebecca. Anything to add, Harriet, at the moment?
No, I think, and just to reiterate the point that, as Susanna said, it's if people have a fear of coming back to work, that's not a reason that they shouldn't be coming back to work. But obviously, bear in mind that you need to be very careful about not subjecting anyone to a detriment because they've expressed that fear. Because ultimately, they could be in a situation where they're blowing the whistle in terms of raising concerns about health and safety. So again, just to be very clear about what the individual's saying, take it seriously, but then making sure that no steps are taken that the individual could use to say that actually you've subjected me to a detriment. So having those proper conversations and finding out really what the individual's concerns are and dealing with them in the right way is obviously the message, as Dean and Susanna have said.
Yeah, that's right. And we've got a question from Rebecca, which we'll deal with in a second, but just can't really overemphasize the importance of, particularly now we've held off on really saying this and the series of webinars we've done over the last 2 years, but now really is the time to absolutely begin to nail down contractually where all of this is going, I think. Again, we would love to help you with all of that, and it's not a big job for us to do so. And then, we can just get the right contractual and policy provisions in place for the workforce. If we need any help with that, drop us a line. I'm sure you've got contact details. I'm at dean.jones@jonschase.com. Drop me an email. With Rebecca, it was a quick question. She's saying, what about individual flexible working requests to work from home, full or part-time, when you haven't decided what the hybrid looks like as a policy? A number of things here. I think now is probably a good time to speed up deciding what hybrid working is going to look like. Again, the way that we do these policies for our clients is you have contractual right to revoke hybrid working should you wish to. Furthermore, include trial periods so you're not locking yourself in, include a contractual right to vary what you're doing as well. And obviously, if you're dealing with a flexible working request, you have to deal with that request in accordance to flexible working legislation. So you can try to, I think, expedite getting a final position on the hybrid working policy with as much wriggle room in there for you to revoke things as much as possible. And again, process the flexible working request on an individual basis in accordance to flexible working legislation. That's what I would do, but try and get the company's hybrid working policy position ahead of the individual flexible working request. I'm not sure if Susanna or Harry anything to add to that, but no, that's it. Okay, that's great. So we are actually going to finish 3 minutes early by the looks of it. And so thank you very much everyone for attending. We had really good attendance today. So just a quick reminder that the information we've covered is accurate as of the 27th of January 2022. If you have any questions, definitely follow up with us, where we'd love to help you. And lastly, if there's anybody else you think would work well with us or would benefit from these webinars and our bulletins, definitely put them in touch with us and we can add them to our distribution list. So as Susanna said, I should have said earlier, Happy New Year, best of luck for 2022. And we look forward to seeing you back in at the last Thursday of February. Okay, thanks very much. Take care and goodbye.
Bye-bye.